The Israeli military says two basic mistakes led to the series of drone strikes that killed 7 staffers from the World Central Kitchen charity. The incident still under investigation. Political writer Ben Domenech says the Biden administration is engaged in bad foreign policy toward Israel because it's listening to anti-Israel voices inside the Democrat Party.
And they are listening to the loudest and the most progressive parts of their own coalition in ways that are ultimately, leading them to break away from America's allies, to undermine them publicly, by the way.
Domenech says the president is under intense pressure from within his own party to put more distance between Israel and the United States. The IRS says it's making progress in cracking down on fraud stemming from the pandemic era.
Hundreds of millions of dollars were improperly distributed under the Employee Retention Credit to help small businesses keep their employees during the pandemic. But IRS initiatives to get that money back are working. For example, the agency said it received $225 million from a voluntary disclosure program, which ended recently.
That is correspondent Greg Clugston. Jackie Quinn reports on a federal investigation underway into the collapse of a construction crane.
Late Thursday, part of a construction crane collapsed onto a drawbridge. Fort Lauderdale Fire Rescue Chief Stephen Golan on WPLG TV says the 27-year-old worker fell down with it.
It was not the crane per se that actually failed. It was a platform that they had equipment staged on.
Golan says additional sections were being added to the crane to accommodate the building getting taller. 3 people were also injured when the segment of steel crushed 2 cars.
It's unbelievable. The amount of cars and traffic backed up, this could have been a whole lot worse.
I'm Jackie Quinn.
And this is SRN News.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Good morning and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. We will be with you for the next hour to answer all of your legal questions. 877-943-9673. That's your live and local number to be part of today's show. Call in with your legal question and we'll be happy to help you live on the air. And the beauty of live radio, by answering your questions, we help not only you, but the rest of the Attorney Patrick Smith Show Nation listening to the show right now. And welcome to all the new listeners of the show. Lots of new listeners every week. We appreciate you, and we appreciate all the warm messages of appreciation about the show. You are the reason why we do it and work so hard during the week to give you a quality hour every Saturday morning of good legal programming. So to be part of the show again, 877-943-9673. Absolutely gorgeous morning outside the studios of the Attorney Patrick Smith Show this morning. And I thought it was going to be cold this weekend. I thought I heard something. I was listening to Drew and John on my drive home, and I think this was on Wednesday when we had that storm come through, and it was supposed to be like severe. I'm getting severe weather alerts, and we had about a 5-minute thunderstorm, and then it was gone, and we never really got cold. So I don't know if the weatherman just got it wrong, but it looks like it's absolutely beautiful outside. So make sure you take advantage of this gorgeous weather we're having today. So we are got an action-packed show for you, of course, and want to start off with a couple of thank yous. So thank you, first of all, to the Military Officers Association of America, who had me come out and speak this past week to their luncheon. Absolutely fantastic turnout and absolutely fantastic question and answer session. I always love speaking before veterans groups. I always feel so outclassed by the amount of service to our country that's just dripping from this room. So again, thank you to Dan and to Bill for booking me. I'm happy to come back anytime you guys would have me. But by far, one of my highlights from speaking at the Military Officers Association of America was meeting a lovely young lady who is a retired member of the United States Air Force. Her name was Doris, and she is 97 years old. She was actually my table mate during lunch, and a fantastic conversation with Doris, and just passing along several pearls of wisdom to me after her 97 years on this earth. And I told her I would say hi to her Saturday morning. So hi, Doris. We appreciate you listening and had a great time talking with you over lunch this past week. So some other speaking engagements coming up this week. For those of you who might be interested in attending, this Thursday, I'll be appearing at the UCP of Central Florida West Orange campus. That'll be Thursday, the 11th at 4:30 p.m. Again, the United Cerebral Palsy of Central Florida. I think they just go by UCP now, of Central Florida, the West Orange campus. And that is in Winter Garden, by the way, for those of you not familiar. That'll be Thursday, April 11th, 4:30 p.m. Also Friday, April 12th, one of our routine reoccurring presentations we do at Kings Ridge over in Claremont. That'll be at 10 a.m. in the Monte Carlo room. So always look forward to the Kings Ridge presentation. Great questions, big crowd. And this will actually be our first time speaking at UCP. So I'm looking forward to that very much. If you want more information about these speaking engagements coming up or any of my future speaking engagements, or if you want to book me to come out and speak to your club, group, church, or organization, reach out to the office. Let's go ahead and give out the office line for the early crowd, 877-754-6764, 877-754-6764 to book us to come and speak to your club, group, or organization. Or if you just want to schedule your complimentary estate planning consultation with me, Attorney Patrick Smith, that's your one toll-free number, 877-754-6764. But to talk to us live today, if you have a legal question and you want to chat live on the air, call screener standing by to get you screened and live on the air with us so we can help you out this morning. 877-943-9673. That's our live and local studio line. 877-943-9673. All right. So our first topic today on the Attorney Patrick Smith Show, let's talk about eminent domain. My gorgeous wife, Christy, actually is one of my most frequent sources of show prep, and she sent me this idea. Her idea and the basis of it was actually a case out of Massachusetts, and I Floridaized this a little bit. So a little bit about Florida eminent domain law. And according to the Institute for Justice in Florida, eminent domain gives the government the power to take your property, even if you don't want to sell. But under the Fifth Amendment, eminent domain must be for a public use. Now, we'll come back to public use because that's going to be a term of some controversy, which traditionally meant projects like roads or bridges. Meanwhile, the government must pay owners, and this is, quote, just compensation for their property, also a term of much debate. What is just compensation? So now there's a Supreme Court ruling called Kelo versus New London, where by a vote of 5-4, the court dramatically expanded the definition of public use to include private economic development. So this, again, no longer roads and bridges. So this is allowing private use application of eminent domain. So in other words, local governments can condemn homes and businesses and transfer them to new owners if government officials think that the new owners will produce more taxes or jobs with the land. Again, according to the Institute of Justice. But Florida, being the wonderful and independent state that we are, responds to Kelo. And Florida has gone from one of the worst states for eminent domain abuse offenders to offering some of the best protection for in the nation for homes, businesses, and houses of worship. So in 2006, so this goes back a ways, the Florida legislature proved that it understood the public outcry caused by the Supreme Court's abandonment of property rights. Florida created a legislative commission to study the use of eminent domain and ways of reining in abuse, then passed House Bill 1567 with an overwhelming majority. The new law, signed by the governor back in 2006, requires localities to wait 10 years before transferring land taken by eminent domain from one owner to another, effectively eliminating condemnations for private commercial development. So House Bill 1567 also forbids the use of eminent domain to eliminate so-called blight, instead of requiring municipalities to use their police powers to address individual properties that actually pose a danger or public health benefit. But it goes on from there. See, they passed the legislation, but that's not all Florida did. Not content with the mere statutory protections, the Florida legislature also put a constitutional amendment on the 2006 ballot so that state citizens could make sure that these reforms could not easily be stripped away. The new amendment, which was approved in a landslide, requires a 3/5 majority vote in both legislative houses to grant exceptions to the state's prohibition against eminent domain for private use. House Bill 1567 and Florida's new constitutional amendment should be models, according to the Institute for Justice, for other state legislatures. They prohibit taking for private benefit while still allowing the government to condemn property for traditional public uses such as roads, bridges, and government buildings. Have you been a victim of eminent domain? Do you have personal knowledge of eminent domain? Give us a call now, 877-943-9673, 877-943-9673, or any other legal question at all. So the statute on point regarding the application of just compensation, we already sort of ferreted out public use. You see there the broadening under the Supreme Court of the United States, and then the narrowing by Florida's response in 2006. So public use to be used for private application, 3/5 majority in both houses. Otherwise, traditional public uses, roads, bridges, government buildings, things like that, perfectly fine. But the other issue is, what is just compensation? Obviously, that can be litigated and people can interpret that very differently. Florida statute 73.071 says any increase or decrease in the value of any property to be acquired which occurs after the scope of the project for which the property is being acquired is known in the market and which is solely a result of knowledge of the project location shall not be considered in arriving at the value of the property. So basically, here's the thing. You can't say this is happening, this use, this acquisition, and allow that to affect the value of the property. So it sort of has to be the value of the property without that knowledge. And it gives you an idea of sort of, we measure that value before the taking, so to speak. But as we were saying, Florida, in response to this past legislation, responding to the Supreme Court decision, Kelo, and then went on to pass a constitutional amendment, a state constitutional amendment. Well, in other state constitutional news, the Supreme Court this week decided and approved a couple of constitutional amendments. First, a little background on constitutional amendments. Now, it differs a little bit between U.S. constitutional amendments and state constitutional amendments. So just a little comparison for those of you interested in that analysis. An amendment to the U.S. Constitution, according to whitehouse.gov, may be proposed by 2/3 vote of both houses of Congress, or if 2/3 of the states request a constitutional convention, then the amendment must be ratified by 3/4 of the state legislatures, or 3/4 of the convention called by the states. So that is the rule for federal or U.S. Constitution amendments, called by 2/3 of the House, 2/3 of the states, then approved by 3/4. Well, what are the rules here in the Sunshine State to amend our Constitution? Now, there's a reason our Constitution looks like a small phone book here in the state of Florida, because as you might guess, it's a little bit easier than the U.S. Constitution amendment process. Proposed amendments to the Florida Constitution may be created by a joint resolution of the Florida legislature, a citizen's initiative, a proposal from the Constitutional Revision Commission, or a proposal from the Taxation and Budget Reform Commission. Once proposed, a proposed amendment requires a 60%. So a lot of people get excited on election night when they see 51, 52. Don't get too excited about the amendments until you see 60 or higher, because it requires a 60% approval from voters to pass. This is according to our state constitution, Article 11, Section 5, for those of you who like to look up these details. Well, in this process, before, somewhere between it starting with the legislature or the constitutional convention here in the states and getting to the ballot, there's a role to play for our state Supreme Court. And that's what we witnessed this past week. The Florida Supreme Court is the final decision maker, okay? And they're actually the ones that will look at the language, and they measure and decide whether the language that is in the amendment is clear and limited to a single subject. That's the standard. And we often know people read these amendments, and people will call my office, and I'm sure they call other attorneys' offices around election time and say, hey, what does this amendment mean? Because it's written in legalese a lot of times. So the Supreme Court here is attempting to make sure that this is written clearly and plainly and addressing a single subject so that we can determine if the average person, the average voter, can understand what they're voting for. And you hear people a lot of times say, hey, if you don't know what it means. Just vote no, everything stays the same. I think that's a little ignorant. And I think that it's worth the time to investigate these things so that you best understand them. So to that end, here are the two amendments that were approved by our Supreme Court, really right at the midnight hour of their deadline. First, Amendment 3. I'm going to read the language. Call in and tell me if you think it makes sense to you. Amendment 3 allows adults 21 years or older to possess, purchase, or use marijuana products and marijuana accessories for non-medical personal consumption by smoking, ingestion, or otherwise. Allows medical marijuana treatment centers and other state licensed entities to acquire, cultivate, process, manufacture, sell, and distribute such products and accessories. Applies to Florida law. Does not change or immunize violations of federal law. Establish possession limits for personal use, allows consistent legislation, defines terms, provides effective date. That is Amendment 3. Amendment 4, probably in the slightly more controversial category. No law shall prohibit, penalize, delay, or restrict abortion before viability, or when necessary to protect the patient's health as determined by the patient's healthcare provider. This amendment does not change the legislator's constitutional authority to require notification to a parent or guardian before a minor has an abortion. So Amendment 4, Amendment 3, what are your thoughts? Is it clear language? Is it confusing language? Call in now, 877-943-9673. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Let's go to my hometown of Winter Haven. Let's talk to James. James, welcome to the Attorney Patrick Smith Show. How can we help you today? Hey, James.
Yes, are you speaking to James McDougall?
Yeah, James, how can we help you?
Oh, okay. I have a question about timeshares. I've owned one for roughly 45 years. And at the present time, I live so strictly on Social Security and a small retirement. But I'm unable to make the maintenance payments anymore. I've offered everything up to even just signing it over back to the original outfit, and can't get any answers. Is there any direction I can go to get some information on this?
Yeah, if you give me a call at the office on Monday, I've got an attorney by the name of Scott Smothers who handles a lot of these cases for me and can negotiate a surrender for you. And a lot of times, you don't have to say which company, but a lot of times Scott has had experience with many different timeshare companies, so he can size it up pretty quickly to let you know if this is going to be one of the easier ones or one of the more difficult ones. But the short version is you basically not only want to give the property back, but you want to get a release from any financial obligation now or in the future. So it's not just the surrender of the property. You do want that release. And that's just from talking to Scott about cases over the years. So don't think that just because you are able to successfully sign it over, you're somehow freed from the financial obligation. It really needs to be that mutual exchange. You give it back in exchange for being released from that financial obligation. Does that make sense, James?
Yes, it does.
Okay. You give me a call at the office on Monday. I'll give out the office line here in a few minutes after we go through a few more callers, and then we'll talk to you and get you in touch with Scott, okay?
Thank you, sir.
You're welcome, James. Have a great day in Winter Haven, okay?
You too. God bless you.
Thank you, sir. 877-943-9673. Give us a call now. This is the Attorney Patrick Smith Show. We've been talking about eminent domain this morning. We've been talking about the constitutional amendment process and pending constitutional amendments, whether or not that language is clear to you. I want to go to Sarasota and talk to Faye, who has an eminent domain comment. Faye, welcome to the Attorney Patrick Smith Show.
Yes, hello, good morning.
Good morning.
My question is, I am one of over 100 people that is in a lawsuit with the city of Sarasota and the county of Sarasota regarding eminent domain on the Legacy Trail. And it's been 6 years. And we have a Judge Meyer here in Sarasota that has not once responded to our lawsuit, refuses to set a date, refuses to respond to our lawyer for any questions. And it's been going on for 6 years. And they've taken over our property to put in the Legacy Trail. And the second part of that is that we found out that they put in fiber optic cable underneath the Legacy Trail, and that they got paid, the city got paid for that fiber optics. from the companies, and that should be part of our lawsuit as well. That's part of our property that they put the fiber optics on. So it's been a frustrating mess. That's all I can say.
Yeah. Faye, I hear the frustration in your voice, and this is just sort of the reality of litigation. And my answer is probably going to frustrate you more than it makes you happy. Since you said you have counsel, I really can't give you too much advice. I will just encourage you by letting you know our judiciary in the state of Florida, we have some excellent judges here. And so if there's a delay, I assure you it's not anything intentional. It's got to be something more procedurally related. And you said you have an attorney. If your attorney wants to reach out to my office, I would love to talk to your counsel about possibly doing a feature on the show about this. And I think I came across this case in my research and show prep this week. So, I mean, it would be kind of fantastic to talk about that with the attorney on the air. And that may be something that we can work out. But otherwise, it's going to really limit my ability to give you any sort of advice, Faye.
Okay. Well, I will definitely reach out to him because he's as frustrated as we are. He already litigated from Venice up to Honore, and that went through very well. The people got compensated, but it's since it hit the Sarasota City with this judge that everything shut down. So, it's already been litigated. It's not, it hasn't been a problem in other parts of Florida. So yes, I'll definitely get in touch with my lawyer and have him call you.
Yeah,
that would be wonderful.
I'll look forward to talking to him and just have him call the office line. I told James in Winter Haven, I'll give out the office line here in a few moments and reach out to me directly. Maybe we can put together a follow-up segment with your attorney calling in. Okay.
Okay. Thank you so much.
Faye, God bless
you.
you.
Appreciate your help.
Yes, ma'am. Good luck. All
Thank you.
Bye-bye. 877-943-9673. 877-943-9673. This is the Attorney Patrick Smith Show, and you're listening to me, Attorney Patrick Smith. Kevin is that supposed to be Thanota-Sassa? I think that's supposed to be Thanota-Sassa. Wants to talk about Amendment 3, and then Mike, we're going to go to you next after Kevin. Kevin, how can we help you today?
Yeah, it's Thanota-Sassa. Sorry if I misspelled it.
That's okay. Go ahead.
Because your screener.
My screener says Thanota-Fatha, and I knew that was wrong.
Okay.
All right, go ahead,
Well,
Kevin.
I'm by I-4 and I-75, so around that area. But anyways, I just had a comment. You know, when they put those clauses in there for the health of the mother, they also write in there for the mental health of the mother, because a lot of people think that, you know, if a baby's breached or something, it might be a significant risk that the mother could die giving birth. But they write in there for the mental health of the mother, and that is so subjective. You know, and why would any woman wait until a late term to have an abortion like that? But they do. It's unreal to me.
Hey, Kevin. So when you interact with as many people as I do, you develop almost a Sherlock Holmesian ability to read people. I'm going to guess you are a pro-life advocate. Am I right?
I am, but I also don't believe it's my purview to tell any woman what she must do. You know, I mean, if it was my child, I would. You know, I wouldn't want to have the child, no doubt.
What gave it away was when you kept referring to them as the mother. The amendment, and even what you said with your last statement, it was a step back from mother. It was a woman. You can see there's a difference between a mother and a woman. If you recognize that the person is a mother, then you are conceding that she has a child. Listen to the amendment. No law shall prohibit, penalize, delay, or restrict abortion before viability when necessary to protect the patient's health. So I think that was a purposeful selection of the term patient, because had they put mother in there, do you see how the tone changes?
That could be the child.
Exactly.
The patient could be the child, correct?
Right. Well, if you notice, the word child doesn't appear at all.
It doesn't. Either mother or child does not appear yet.
Right. And that's the point about why we have the Supreme Court look at this language. It's not just necessarily that it's confusing. It's also what words are you selecting for this amendment? Every word matters here, and that is a great example.
Yeah.
That's a great example. The difference between mother versus woman versus patient.
And child versus patient or whatever. But I mean, that's the way that these things are purposely confusing sometimes.
Yeah.
Some of these amendments.
Well, Kevin, when we did the show on Dodd, which was the Supreme Court decision overturning Roe versus Wade, we did 4 parts on it. And I took calls over that month of broadcasting and asked the listeners 2 questions without expressing pro-life, pro-choice. I said, does the Constitution have a right to privacy? And should the states or should the federal government decide the scope of the right to privacy, whether they were pro-life or pro-choice? There was almost unanimity in the fact that there is a right to privacy under the Constitution and that the states should decide the scope individually as to what the right of privacy was in each state. So that's why I predicted, and I still think it's coming, we are going to get an amendment eventually to our U.S. Constitution with regard to that. But absolutely fantastic call, Kevin. Really appreciate you calling in.
Thank you, sir. Take care.
Have a great day.
Bye-bye.
All righty, 877-943-9673. That's your live and local number. Yeah, I mean, the big difference there, patient's health versus mother's health versus woman's health. I mean, you could just see the difference right there. That's just one word. So, I mean, the Supreme Court going right up to that deadline to approve it, that's just showing you how hard they're working for us up there in Tallahassee. The Supreme Court is a hard-working group of justices. So next, we're going to go talk to a very patient Mike in Largo. Mike in Largo, how are you doing today?
Very good, sir. How you doing?
I'm better than I deserve, Mike. What's going on?
Well, I formed a trust about a decade ago, or had a lawyer form a trust about a decade ago. I funded it almost completely. He had him put the my house in the trust, and funded everything else myself. The one thing I didn't do was I have a business which is a sole proprietor, with a contract through a large bakery. And as I get older, obviously, I'm just kind of concerned about what may happen if something happens to me, I pass away. What would happen with my family if it's not in the trust?
Well, it would be probated, but there are ways you can assign it to the trust so that it can avoid the probate process. It's not the end of the world. So is your existing counsel still in practice?
I don't know. I haven't even attempted.
Look them up. I mean, so you just go to the Florida Bar website, type in their name. You can search by name, and if it's one of those kind of funny names to spell, I think they even give you a sounds like option now, and you can just look them up that way. And if for some reason they're not in practice and you just want someone to put a fresh set of eyes on it, might give me a call. We'll meet with you in the Clearwater office where I was at all day yesterday. Very long day in the Clearwater office. So yeah, just give us a call and we'll be happy to help if your existing counsel is no longer in practice.
All right. Thank you very much.
All right. Thank you, Mike. Have a great day. 877-943-9673. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. If you want to reach out to me at the office, like James for a referral, or maybe like Mike for a complimentary consultation to review existing documents, again, that office line, 877-754-6764, 877-754-6764. Office lines are open, by the way, every Monday through Friday, 8 a.m. to 4:30 p.m. And you can reach out to that office. Any member of the staff will be happy to get you scheduled for your appointment, get your message into me if you just need a referral, or if you want to book us to come and speak to your club group or organization or church group. 877-754-6764. Give us a call now to be part of the show. 877-943-9673. Live and local studio lines wide open. Give us a call now. 877-943-9673. All right, let's go to Bradenton. Let's talk to Kevin about eminent domain. Kevin, welcome to the show.
Hey, good morning, Patrick.
How's Bradenton this morning?
Another beautiful day in paradise.
Yeah, it is gorgeous down there. I agree with you. So how can we help you, Kevin?
Hi. Just telling you my experience with DOT and an eminent domain. I had a building, state wanted to widen the road, came in, started making ridiculous offers. I happened to meet a good attorney in Sarasota, and he did eminent domain. Called him up. He said, "Don't sign anything. I'll take care of it." And sure enough, it got to be a fight. They only wanted to pay for my parking lot and not the building. but they made the building useless by taking the parking lot.
Well, and that's
And,
the point. That's the point of Florida Statute 73. They said basically, if the eminent domain taking affects the value, you can't do that and then say, oh, we're going to give you that value because that's what it's valued at now. You have to value it basically immediately prior to that. So you said they made ridiculous offers. So if you don't mind sharing, what was their offer? What was the market value? And then what did you actually accept, if you don't mind sharing, Kevin?
The offer was about $45,000 just for the parking lot. Gave it all to him. He took great care of it. We settled for about $250,000. And unfortunately, a friend of mine that was on the same road, they tried handling it themselves. Didn't come out nearly as good. So my whole idea was, I'm so happy I hired an eminent domain attorney.
Well, and that just goes to show you the value of hiring good counsel, whether it's to draft a will or if it's eminent domain or if it's a personal injury case. It's a 1 or a 0. You either had an attorney or you did not. And it sounds like you got a good one there. And that's worth all the money in the world if you get that result that gives you peace of mind at the end of the case, Kevin. And it sounds like your attorney did that for you.
He did a wonderful job. First thing he said was, a couple nice ladies came in and they said, would you like to donate the property? And he says, of course, you're not going to say yes. And we started that. It kind of drug out till, I want to say, going towards October, and they seemed to have a deadline for that. And they were like, well, you don't want to cooperate. And it's like, well, you're taking the whole building, you're going to pay for it. And it worked out good. I have no complaints. I had no idea what a eminent domain attorney was until this guy enlightened me.
Well, you do now. So if it happens again, you know who to call, it sounds like. And it's one of those situations where just compensation, like I said, that's highly debatable. So having good counsel who argue those facts for you, it's kind of like, what is equitable distribution in a divorce? I mean, that can be litigated and negotiated. So sounds like you got a good attorney who negotiated a great result for your just compensation there, Kevin. So happy to hear of the good ending with that story.
The plus side of that is what people, unless it's changed, when I call him, he says, you don't pay me. The state pays for my bill. So it costs me nothing to get an expert.
All right. Can I ask a personal question?
Yes, sir.
What'd you do with the money?
Invested in more real estate.
You're so consistent, Kevin. Good for you. You immediately doubled down and dared the state to take that property too, right?
Well, it was funny because there was extenuating parts of the building, and they only wanted to look at one half, and we said, no, you're taking the whole building. It worked out quite well because right after they took part of the property, Eckerd Drugs came along and paid me a bunch of money for the rest of the property. So.
That's so funny. That reminds me of I think it was an old Coca-Cola commercial where it was two brothers, and they said, hey, one brother said, hey, you want to split the Coke with me? And he goes, yeah, sure. And then the brother with the Coke drank the whole thing. He said, sorry, my half was on the bottom.
That's right.
So, yeah. Anyway, Kevin, we appreciate you calling in. Enjoy Bradenton and have a great rest of your Saturday, okay?
Thank you for your show.
Absolutely. Appreciate you. Thank you. 877-943-9673. This is the Attorney Patrick Smith Show. We do appreciate all your kind words about the show, the messages, the calls to the office throughout the week. I mean it from the bottom of my heart when I say thank you. You are the reason why we do this show. So 877-943-9673 to be part of the Attorney Patrick Smith Show today. Let's go to Bradenton. A lot of calls from Bradenton today. Good job, Bradenton. Let's talk to Steve. Steve, welcome to the Attorney Patrick Smith Show.
Good morning, sir. Thank you for taking my call.
Of course, Steve. How can we help you?
Well, I'll give you the quick bullet point version. Was in business for myself. Just couldn't make it. Closed the business. I had a new truck on order. Obviously a loan for it. Never made a late payment. Payments are current. Get a 10-day notice yesterday from the bank calling the loan in. Even though I'm current, the truck's insured. It's in the process of being sold. They're calling the loan in, saying that because I'm no longer in business, I'm in breach of contract with them.
Yeah, you probably are. My guess would be they're not reading that wrong. It's probably in all that fine print you signed, Steve.
It's in there. It's in there.
Oh, you already saw it then. So yeah, it's just a matter of negotiating with them at this point, because it sounds like you may actually be in breach. You may have to hire civil litigation counsel to represent you. Do you already have counsel, Steve?
I'm just going to reach out to my business attorney Monday morning.
Yeah,
but,
start there. If you've got a guy you know, start there. If for some reason he passes on the case or can't give you a referral, just call me and I'll put you in touch with someone who can take a good look at the contract and tell you what options you have to sort of settle or remedy that matter. Okay.
Yeah, I'm just trying to get. Really, I just need a few. The truck was on order, so it was being built, and it got delayed, and so it finally got finished last week. I've got several potential buyers. It will sell.
What kind of truck? I'm just curious now.
It's a large tow truck.
Okay. Yeah. Yeah.
So, but it's brand new. It's never been used. It's off the assembly line. And I've never made a late payment, kept the insurance up on it. But because they got a notice, I transferred the insurance from a business to a personal name. They noticed that I'm no longer a business, so they want their money, even though I'm not behind.
I want to clarify. You said you've never made a late payment. One possible interpretation of that is you've never been charged with a late payment. Another one is there are late payments that you have never made. Which one is
No. I've been current. They've automatic withdraw from the bank account.
So you've never incurred any late payments. Got it.
No, and the truck has been on order for almost 7 months. It was only supposed to take 6 weeks, but shortages. So they've been deducting that from my account directly. So everything's been paid on time.
Yeah. Hello, supply chain issues, right?
Well, I think some businesses are taking advantage of that now, but that's just, probably another topic.
Yeah, that's a whole nother show, wouldn't it be, Steve? So, Steve, give your lawyer a call. If for some reason it doesn't work out with your current attorney, give me a call. I'll be happy to give you a recommendation, okay?
I appreciate it. Have a great day, sir.
Thank you, Steve. Good luck. 877-943-9673. Straight to Bob in Sarasota. Bob, how's Sarasota today?
It's beautiful. Always.
Yeah, Sarasota's gorgeous. My wife's grandmother used to have she still technically does have a timeshare down there, and it's absolutely majestic. St. Armand Circle, one of my favorite places to go people watch and car watch, usually while nibbling on something delicious from Kilwins. So how can we help you today, Bob?
Well, I'm always excited this time of the year because I'm hoping the snowbirds are heading north.
Well, you know what I've noticed is it's sort of we have crossfire. I've noticed we have a lot leaving, but we also have a lot flowing in this time of year, which is different. But anyway, how can we help you, Bob?
Yeah. Okay, so my question was about Amendment 3, the marijuana amendment.
Yeah, go ahead.
It's my understanding, I know people that have them, medical marijuana cards.
Okay.
And they kind of explained to me the process, and it seems kind of like, I don't want to use the word scam, but just kind of funny that the way you have to get a medical marijuana card is really about money.
No.
You have to pay $250 for an examination, $75 for a card for 1 year. You have to get an exam every 7 months for another $150. And if you don't get that exam after 7 months, you can't buy any marijuana from the 7th to the 12th month.
Well, yeah, Bob. I mean, I agree with you that there's certainly, I don't know, I agree 100% with the numbers. I haven't checked all those out. But I do agree with the fact that there is a financial drive here, because if you legalize medical marijuana, if you legalize recreational marijuana, what can you now do to marijuana if you're the government?
Well, my question about Amendment 3 is, I heard you, I heard you read it, but it's basically saying I don't need a medical marijuana card anymore.
I don't know that that's what it's saying, because listen to the amendment again. All right, we'll read it again. But to go back, the answer to my question was they can tax it. If it's legal, if the sale is legal, taxes can now be recouped on the sale of medical marijuana. So here's the amendment language again for those of you joining us late. We did a top of the show about eminent domain. Then we went into constitutional amendments like the one passed for eminent domain. Here is the proposed language approved by our Florida State Supreme Court this past week. allows adults 21 years or older to possess, purchase, and use marijuana products and marijuana accessories for non-medical personal consumption by smoking, ingestion, or otherwise. Allows medical marijuana treatment centers and other state licensed entities to acquire, cultivate, process, manufacture, sell, and distribute such products and accessories. Applies to Florida law, does not change or immunize violations of federal law, because, by the way, still illegal federally, marijuana. Establishes possession limits for personal use, allows consistent legislation, defines terms, provides effective date. So the reason why I say I don't know that you may not need your medical marijuana card, but what if you have someone who's 19?
Well, that's true.
So, I mean, listen, this is for 21 and above. So I think if you're someone who does suffer from an ailment and a medical doctor prescribes you medical marijuana, obviously you're not going to hide under the recreational amendment. You're going to continue under your doctor's care. And indeed, I would argue if you're under a doctor's care, I still think you're going to maintain your relationship with your physician. I don't think you're simply going to say, I don't need to go see my doctor anymore.
No. My question is this, because my understanding, like I said, is that these places that sell medical marijuana, right, only will sell you that if you have a card, right? So it's kind of a, closed group, they can sell it. If we go to Amendment 3, does that mean other entities who don't necessarily require the card will be able to sell it?
Yeah, I think that's a great question. So not only sell, but manufacture. I mean, because if you look at it, it says allows other state licensed. There's the key word. The state will license. That's not going to be easy. And I think it's going to be a lot of the large manufacturers of marijuana who are going to dominate getting those licenses. A lot of the ones who are influencing the passage of this amendment is, should it pass, manufacture, sell, process, cultivate. So, I mean, you see the broadness of this potential amendment, but I think it's going to be narrowed by that licensing process. But an absolutely fantastic point, Bob.
Well, it may be narrowed, but right now it's completely closed. There's only a handful of people, that have those licenses, and that's it. And, you can't open a new store unless you've got that license, right? So this should open it up to other people. Now, I don't know how many licenses they're going to hand out, but I'm sure they're going to hand them out.
Yeah, it may
be. It puts a little competition.
It could be as expensive or as difficult as like getting a medallion to operate a New York City cab. I mean, you just don't know what's going to happen there. But you're right. I mean, it could be. There's other states where I think it's ridiculous. I think some state in my research said something like it's a 50% tax in the state. So, I mean, you just don't know what each jurisdiction is going to do with it. So I think that this gets read one way, but the practical application, I think, is going to be much different from what most people envision based on that language. And that's why the Supreme Court looks at these things, because you read it and think one thing, and then it plays out totally different. And you're like, that's not what I voted for. So that's why the Supreme Court helps us on this.
And that amendment is coming up for vote in November?
Yes.
Okay.
And it requires 60%. So if that night you see 58, don't get excited. It takes 60 to pass. Okay.
I don't get excited at my age anymore.
All right, Bob, enjoy Sarasota.
Thank you.
877-943-9673. Carl, I'm going to come to you in a second, but Mary has been very patient in St. Pete. Mary, how can we help you today?
Hi, good morning.
Good morning.
I just wanted to ask a really short question and ask you as a lawyer, did you hear about the law they passed in Oregon that says you don't have to take the bar exam anymore to be a lawyer? And I thought that was outlandish.
No, I did not hear about this.
I heard it on the radio and I thought it's just another indication of, think about it. I wouldn't want to hire that guy. I was just wondering if you had heard about it.
I'm checking as we speak in real time. I'm an intern in studio this morning, so I'm checking right now to see what I can find on that. And you think that would... Now, I remember in researching this a while ago, and we actually have a whole lawyer, attorney, different thing queued up. We've never gotten to it. I've had it in the queue for like a month now. Let's see here. This is according to legal.io. Starting May 2024, law graduates will be able to become licensed in Oregon without taking the bar exam. There you go, Mary.
And so I guess if you want to be a lawyer, you want to move up to Oregon, correct?
Well, I mean, I think so. To me, the way I read this from a public policy standpoint, they must be hemorrhaging lawyers there and not having as many admitted. So this would be a way to correct that by encouraging people to practice in Oregon as opposed to leaving Oregon and going practicing in different states. That's how I read it. But apparently that is the case according to legal.io, at least. So, Mary, great point. But no, believe it or not, Florida law keeps me pretty busy, so I don't often check Oregon laws. But Mary, I appreciate you calling in to keep me aware of it.
Thank you very much.
Thank you, Mary. 877-943-9673. Carl, I am very excited. I have no idea what kind of question is going to result from this, but please, the floor is yours, Carl.
Hey, quick question about adding to the medical marijuana. Well, not a question, more. My doctor told me as well, if you keep your card, there's going to be some taxes that are going to be lessened if you're not just buying it for, I guess, medicinal purposes. Is that correct? And then also he even said strains. There's certain strains that are for medical purposes, whether it's cancer patients, whatever, that are stronger, that they're also not going to sell to the public.
Yeah. So, I mean, it says establishes possession limits for personal use, and it applies to Florida law, does not change federal, and they have the right to license the cultivation process manufacturer. So yeah, I read that as to say they have the ability to tax it. So yeah, stay tuned. They could tax it. And they could tax wherever they wanted.
The reason for my call about the dinner deal, I was curious, when you take a cat named Mo out to dinner,
oh gosh,
does he bring home a separate meal for the family like he did with me? Or does he just do that to me?
Did he do that to you?
Like 6 times.
That's really funny, Carl. No, we had a great time. That was a great guys' night out.
Did he steal that bottle he took a picture of, that liquor he was drinking, and take it home?
There was no bottle of liquor. I don't know what picture you're talking about. That's funny.
You check your credit card statement after you ate with him that night?
That's funny. No, we had an absolutely fantastic time. John Sinning and Mo and I had a wonderful meal at Urban Stillhouse in St. Pete last Saturday. So no, great time was had by all. All right, quickly, let's go to Joanne in Sarasota. Joanne, how are you doing today?
I'm doing fine.
How can we help? I got a couple minutes
I
here,
hope
Joanne.
You are as well.
Yeah, I've got a couple minutes, so it's got to be kind of quickish.
Long story short, I mean, why are we considering this? Look at Oregon. It became a cesspool, and now they're reversing the law.
So you think we're moving the wrong direction?
I think we should not legalize marijuana. As a mother who watched teens get involved with it, some pulled out of it, it was a phase, and others are still taking drugs in their middle 40s.
You mean for recreational use? I presume
Right.
You don't
It's
have a problem with it when it's under a doctor's supervision for medical treatment.
Well, I think there are a lot of treatments out there. I think that's a guise to use marijuana. But marijuana is being grown here in the state right now.
Joanne, can I ask you a personal question?
Sure.
You ever used marijuana?
No.
Do you think I don't know how to phrase this. Do you think if you had an ailment where a doctor prescribed it to you to treat the ailment, do you think you would take the doctor's advice and try the treatment?
Probably not. I've already had serious ailments. I'm quite a senior citizen. I've had a chance to observe the world. You know what I'm saying?
Joanne, I love how principled you are. So thank you for calling in. I appreciate it.
Okay. Bye-bye.
All right, bye-bye. 877-943-9673. Bob in Sarasota, I have about 30 seconds, Bob. Can you do it in 30 seconds?
I can.
Go.
No, I have a living trust. I bought 3 income annuities when I was 49 and a half. At 59 and a half, which I turned on all 3 income switches. So I get paid forever. And they're telling me the payments are 100% taxable and there's no return of principal. And that's just not what they told me when I bought the policies.
All right,
They're saying it's covered. Go ahead.
3-way conversation. You're going to talk to an attorney, your accountant, your financial advisor. You'll have to call me at the office on Monday, Bob. But if you're missing any one of those pieces, I'm happy to plug somebody in for you, okay?
Okay, great.
All right. And we have a Sarasota office, too. So if you need an attorney, we're right there in Lakewood Ranch, okay?
Thank you.
You're welcome. All righty. This is the Attorney Patrick Smith Show. Action-packed hour. It is the fastest hour on Saturday morning, folks. We've covered a lot. Eminent domain, constitutional law, constitutional amendments. So don't forget our speaking engagements coming up this week at Kings Ridge on Friday, April 12th at 10 a.m. in the Monte Carlo room. And then Thursday at UCP of Central Florida West Orange campus, 4:30 p.m. on April 11th. To reach us at the office during the week, 877-754-6764. Take advantage of our $75 wills or our $695 trust packages for non-taxable estates. That toll-free office line for a referral to book us to come and speak to your group or to schedule your complimentary consultation with me, Attorney Patrick Smith, at the Clearwater, Sarasota, Sun City Center, any of our office locations, 877-754-6764. Everybody, God bless, stay safe, and go Gators.